Welcome to this presentation on canon law and safe environment work in the church. Specifically, we are here to discuss what has changed recently in canon law and how it affects your role in creating and maintaining safe environments in your diocese. You may have heard that earlier this year, Pope Francis issued a revision to an entire section of the Code of Canon Law, or what is known as Book 6 of the Code, which covers delicts or canonical crimes and what the church is to do in response to those crimes. So this webinar will offer an overview of the specific changes that were made in the code that relate to safe environment work. Namely, what has changed in the law that relates to addressing situations of sexual abuse, assault, and exploitation in the church. So we'll go through the specific changes that were made that pertain to this area, and what we will see is that while Pope Francis technically made a major revision to a long-standing body of law, because the Code of Canon Law has essentially been the same since it was last promulgated almost 40 years ago, and while revising and re-promulgating an entire section of that code, it's a pretty big deal, the changes that were made are not actually going to have a seismic effect on your day-to-day work for the church. And we'll talk about why that is and why these changes are still really important for the overall trajectory of keeping our church safe, and why it's also important for you to have an understanding of what these changes are. So one reason that you will not see big changes to how you do your job as a result of these new canons is that in many ways, these changes made, they simply bring the Code of Canon Law up to date with the progression of penal law that has been ongoing now for a few decades. Now, a code of law, it's intended to be a stable body of legislation that's to be written in such a way that frequent updates to it are not actually necessary. But in the area of penal law, which covers crime and punishment in the church, it became apparent that the penal legislation that was put into place in 1983, it was not sufficient to respond in a practical way to the serious difficulties that the church was facing, especially in regards to clerical sexual abuse of minors. So changes to the church's penal law that governed how clerical sexual abuse cases are to be handled started to be made actually back in the 1990s. And they were made by way of legislation that's actually outside of the Code of Canon Law. So I got my code here. The canons in this book remain the same, but they were actually superseded by the legislation that came later. And over the course of about 30 years, the number of changes that were made outside of the code, they really began to accumulate. Now, one thing that this revision that just happened does, it's incorporate those changes into the text of the canons. So the canons in the code, in the book, they reflect the current reality of the law. So when we say that changes were necessary to the penal law, this need actually went beyond just adding more specific ways to handle sexual abuse cases. Otherwise, Pope Francis could have just changed a few canons in this area, bring them up to date, call it good. As a church, we've been through a lot of difficulty and suffering and scandal from the sexual abuse crisis. And as we commonly hear, the pain of that experience has been in large part due to the way that these cases were handled by church authority or mishandled. One of the common complaints has been that bishops and others in a position of authority did not apply the canonical remedies that were available to them in the form of discipline or penalties when abuse or misconduct occurred. And then a common response to that criticism has been that the canonical processes were too cumbersome or complicated to use, and that as a church, we should really be focused on less legalistic remedies such as repentance and reform and mercy. Overall, history is showing us that far too often penalties were not applied when they should have been, to the detriment of the church and the community. Now, the reasons for why things happened the way they did, and in some ways are still happening, they're complex. And we've learned a lot from this experience. We've learned a lot from victim survivors and those who advocate for them. We've learned a lot from the social sciences and legal experts. And we still have a lot to learn about how systemic and cultural factors in the church contribute to these issues. But our law is a product of the values of our community. Our law reflects the culture that we have, or at least the culture that we want to have and protect. So revising the law isn't going to solve all of our problems, but it is one important piece of the puzzle. So a full and comprehensive revision to the book that covers delicts and penalties is part of the effort to incorporate the updates that are needed to make sure the law reflects what we as a church has learned through past experience and feedback from the community about what are the tools and standards that are needed in the law to respond effectively to harmful behavior. And making those updates and revisions in order to deal with harmful behavior more effectively and with more consistency throughout the church, that's what the new penal canons are all about. So I mentioned that this revision work has been going on piecemeal for a few decades now. And the revision of the whole Book 6 of the Code of Canon Law actually began under Pope Benedict. And Pope Francis has issued some of his own penal legislation outside of the code in the past few years. One of the most significant was his motu proprio called Vos Estis Lux Mundi, which implemented mandatory reporting requirements for sexual abuse in the church and also instituted a process for investigating bishops and others in authority for not handling abuse cases properly. We'll talk a bit more about Vos Estis later on. But this past May, Pope Francis finally revealed the revised penal canons, the revised Book 6 that we had been waiting for so long. At least canon lawyers have been waiting for it for so long. The new canons were introduced this past May, but they go into effect on December 8, 2021. So Pope Francis promulgated the new canons by way of an apostolic constitution called Pascite Gregem Dei, which means tending the flock of God. And in that document, Pope Francis explained his motivation for issuing these revised penal norms now, and he used some pretty strong words. This is what he said. In the past, great damage was done by a failure to appreciate the close relationship existing in the church between the exercise of charity and recourse, where circumstances and justice so require, to disciplinary sanctions. This manner of thinking, as we've learned from experience, risks leading to tolerating immoral conduct, for which mere exhortations or suggestions are insufficient remedies. This situation often brings with it the danger that over time such conduct may become entrenched, making correction more difficult and in many cases creating scandal and confusion among the faithful. For this reason, it becomes necessary for bishops and superiors to inflict penalties. Negligence on the part of a bishop in resorting to the penal system is a sign that he has failed to carry out his duties honestly and faithfully. These are the words of our Holy Father, introducing the new penal laws of the Church. We see him calling upon bishops to do the hard work required of them in the exercise of their office, and warning them that they will be held accountable to follow the canonical processes that exist. We'll talk more about accountability toward the end of this webinar. For now, let's take a look at the specific changes that were made to the canons that relate to safe environment issues. So let's start with reviewing Canon 1395-2 of the 1983 Code of Canon Law. You see it there on the left. This canon was the primary source of legislation governing sexual crimes by clergy in the 1983 Code. And you can see that it lists a series of offenses ranging from forced sexual assault to public sexual acts to sexual abuse of a minor. It's all there in one place. Now, on the right, you see the revised Canon 1395-2 that takes effect on December 8th. It starts off sounding very similar, but when you read it, you can see that it only deals with sexual offenses by clergy that are committed in public. The reference to other offenses committed by force, threats, or with minors has been removed. Interesting. Those other offenses listed in the original canon are now being covered in other canons, and we'll look at each of them coming up. But before we talk about what has changed, I want to note something that is not changed in the revised law, and that is the use of the phrase offense against the sixth commandment of the Decalogue to describe sexual offenses. Offense against the sixth commandment of the Decalogue. Let's talk for a minute about what this phrase means and why the Church uses it in canonical documents instead of saying sexual abuse. First of all, what's the Decalogue? That means the 10 Commandments. What's the 6th commandment? That says you shall not commit adultery. So on its face, if you read it literally, it looks like the church is only prohibiting adultery when it mentions delicts against the 6th commandment of the Decalogue. But that's not what it means in this canonical context. The Catechism of the Catholic Church tells us that the church has traditionally understood the 6th commandment as not being limited just to adultery, but as a reference to the whole of sexuality and sexual behavior. And you can see this spelled out in the Catechism's extensive treatment of the virtue of chastity under this commandment. So another way to think about what delicts against the 6th commandment means is that they're offenses against chastity or sexual offenses. So why do we use this long, complicated phrase? Why don't we just say sexual abuse? Essentially, while all cases of sexual abuse are delicts against the 6th commandment, not all delicts against the 6th commandment are sexual abuse. So by citing the 6th commandment, the church can actually cast a really wide net. If it's an offense against chastity, it's an offense against the 6th commandment. So in this way, the church has a more expansive concept of what constitutes sexual delictual behavior in certain circumstances than any civil statute ever will. So the primary benefit is that using this term gives us plenty of flexibility when it comes to identifying and following up on sexual offenses when they occur in whatever manner. And you can contrast this approach to how criminal statutes in civil law are drafted. They are long and complex, and they account in detail the types of crimes, how they're committed, and assigned levels of degrees for how bad they are. And there's certainly some benefit to that approach, to having it spelled out. What exactly are you looking for? And when we use this broad category in the church, it does put a certain onus on ecclesiastical authority to assess the facts and circumstances of what occurred, identify this as delictual conduct, and then apply the law appropriately. And that there, while it is an advantage to have the flexibility in the system, it's also one of the drawbacks. Without having offenses spelled out in detail, there can be a lack of clarity as to what to do in response to a specific action. It's not always obvious as to whether what is presented is a delict, a crime against the 6th commandment or not. And where we often have the most difficulty is with what are often referred to as boundary violations. Some behavior that might be creepy or weird, or it might make us uncomfortable, but it's not clear as to whether it's sexual abuse or even something sexual at all. Is that a delict against the 6th commandment of the Decalogue? It can be hard to tell. A judgment call has to be made there. So we continue to use this phrase in canon law, being mindful of its advantages and disadvantages. It's helpful to remember that this is the text of the law saying that when this delict occurs, this is what the church authority has to do in response. We can use other tools to help provide the clarity that we need and that more specific wording would bring. So diocesan policies or your code of conduct, for example, could indicate with more specificity what constitutes sexual abuse or misconduct. And these standards can and should be informed by your local civil law standards and statutes. We just need to understand that when it comes to what constitutes a canonical crime that triggers a canonical process, the canonical standard is an offense against the 6th commandment of the Decalogue. Okay, so with that covered, let's move on to see how the canon has changed. So what we'll see is that Canon 1395, which we're looking at the second paragraph there of the 1983 version and then the new version, that canon now has a third paragraph added. So let's put that up for you to see. You can see that this new third paragraph includes the forms of sexual assault by force or threats that were previously included in the second paragraph. But there's something new and significant added here, which is a reference to committing sexual offenses by abuse of authority. We also have a distinction now made between sexual offenses committed by the cleric himself, which is in the first part of paragraph 3, and those where the cleric forces another person to perform or submit to sexual acts, which is the second part of paragraph 3. Sexual offenses with minors are still not mentioned here. We'll get to that in a minute. What can we say about these particular changes to Canon 1395? First, we have the difference between paragraphs 2 and 3. Paragraph 2 is essentially about serious sexual misconduct of a cleric that goes beyond a moral failing or a sin because of its public nature. It's out there publicly, therefore it requires a canonical criminal process. Paragraph 3 includes forms of what can be described as sexual assault, either with the cleric himself or the cleric forcing another person to engage in sexual acts. There is an explicit reference there to abuse of authority in the assault, which is a new addition to the text of the law. I think it's fair to say that this reference to the abuse of authority is in direct response to what the church has been hearing from victim survivors and those who work with them regarding the harm that is done in those abusive situations involving two adults where there is an imbalance of power. Now, I don't want to overstate this. The canon doesn't say that sexual contact with a cleric in a power imbalance relationship is by that fact a crime in canon law. But this reference to an offense against the Sixth Commandment carried out through abuse of authority, it certainly provides the canonical basis to pursue a penal process when those facts are present. So now this canon takes effect on December 8, 2021. Now, does that mean that prior to December 8th, that a delict against the Sixth Commandment committed by a cleric through the abuse of authority was not a crime and therefore could not be punished through a canonical penal process? Not exactly. Under the previous law, it could have been used to punish this type of offense, but it was less clear that this type of misconduct actually rose to the level of a crime and that the bishop had an obligation to pursue a formal penal process. So with this revised canon, there's much less ambiguity, and it's much harder to come to the conclusion that these offenses should not be subject to a penal process. It is helpful to have this spelled out in this way in the text of the law. We can also look at the title under which this canon is listed. It's essentially the same as it was in 1983, Offenses Against Special Obligations. This title refers to a group of canons that deal with delictual conduct that the church has a particular interest in punishing because of the incompatibility of the behavior with the clerical state. Because the church doesn't punish through a canonical process every act of sexual assault that's committed by any Catholic out there. That would be something for the secular state to pursue on a criminal level. But when the crime is done by somebody holding a particular office in the church and representing the church's mission, then the church has a responsibility to follow up on that for the good of the mission and order and protection of others who belong to this community. So other delicts that are included in this section on special obligations of clergy include, besides some other types of sexual offenses, things like exercising a business or trade for profit, or violating the requirement to live in a certain location by reason of office, such as like when a pastor is obligated to live in a rectory at the parish. These are offenses that are harmful to the dignity of the clerical state. So sexual abuse of minors has been moved out of this section as part of a recognition that that particular offense is of a level of gravity that's beyond even this title. So let's take a look at that now. On the left is the same text of the 1983 canon 1395-2 that we've already been reviewing. Bolded there are the parts of that canon that refer to the delict of sexual abuse of minors. And on the right is what we have for the beginning of a new canon in the revised law, which is where the delict of sexual abuse of a minor has been moved to. Now we'll look at the whole of the new canon 1398, but right now let's focus specifically on how the canon related to clerical sexual abuse of minors has changed. First of all, I mentioned that sexual abuse of minors is no longer included under the title of Delicts Against Special Obligations. A new title has been created called Delicts Against Life, Dignity, and Human Freedom. Now this is an adaptation of an existing title that included Delicts Against Life and Human Freedom, but the word dignity has been added here. Now we can see this as a legal recognition of sexual abuse as a crime against human dignity. It's not considered solely a moral failing or a failing of clerical obligations. Again, this is something that the church has learned by listening to victim survivors and their advocates, as well as experts in human sciences and health. Looking at the text of the canon itself, there's a subtle but important difference here in how it's worded. The 1983 version of the law begins with a list of different types of delicts against the Sixth Commandment that a cleric could commit, and then says he's to be punished. The new canon starts out with the statement that a cleric is to be punished if he commits an offense against the Sixth Commandment with a minor. There's a heightened emphasis on the obligation to punish the crime. We also see that the revised canon says he is to be punished with deprivation from office, along with any other appropriate penalties. Now, that statement about deprivation from office, it's not in the 1983 canon. Certainly, deprivation from office was one of the just penalties that a bishop could impose, but in the new canon, the penalty is no longer discretionary. He is to be punished with deprivation from office, end of story. This essentially means he must be removed from ministry. Now, this has been the standard for many years, but now we have it codified in the law. We also see that the revised law only refers to a minor, whereas the 1983 law said a minor below age 16. The age of a minor for sexual abuse has been set at 18 for a couple decades now, so the new canon brings the code up to date with what has already been established in other legislative documents. Now, I have an ellipsis there at the end because the rest of the canon includes a whole bunch of stuff that we'll cover in just the next few minutes. But I want to focus right now on the specific provisions that are related to sexual abuse of minors right here. But this new canon, 1398, is like a new super canon on sexual abuse. So let's take a look at the rest of it. Here is the first paragraph of the new canon 1398 with the first subparagraph included. We already saw most of what's here on the previous slide, but now you have the rest of the first subparagraph. And we can see that this subparagraph covers not only sexual abuse of minors, but also sexual abuse of persons who habitually have an imperfect use of reason, and also sexual abuse of those to whom the law recognizes equal protection. So first, let's talk about those who habitually have an imperfect use of reason. This has been the standard of canon law for 2 decades now, that sexual abuse of these persons is not only a serious crime, but it is akin to sexual abuse of a minor. So like with other provisions that were introduced into the law after the 1983 code was issued, adding this phrase to the canon is catching the code up to where canon law has been for a long time. This acknowledgement that persons who habitually have the imperfect use of reason are equivalent to a minor, that's noted in the text of the charter, if you're wondering where you might have seen it before. So while the canon itself is new, the concept is nothing new in canon law. Habitually having the imperfect use of reason essentially means having an ongoing mental incapacity that makes the person unable to be treated as an adult legally. It's a pretty restrictive category. So what is really new and has raised a lot of questions and discussion is the last phrase there, referring to sexual abuse of one to whom the law recognizes equal protection. What does that mean? The concept that this is getting at is a type of vulnerable adult. Now we need to be careful here. I know that the topic of abuse of vulnerable persons is something that many of us are eager to learn more about and to see more robust processes to help us respond to these situations. Notice that the canon says, one to whom the law recognizes equal protection. That phrase was chosen intentionally instead of including a reference to vulnerable adult. So the reason for not stating vulnerable adult here is similar to the reason that the canon says an offense against the Sixth Commandment instead of sexual abuse. Remember that this is legislation for the universal church all over the world, and it needs to be applicable to many different cultures and contexts. So the idea of what makes a person a vulnerable adult is not one where we have a set standard in law that can simply be applied here. So what this canon does is leave open the possibility that, along with sexual abuse of minors and sexual abuse of those who habitually have an imperfect use of reason, there could be another category of persons whom the law offers specific protections to from sexual abuse. So let's unpack this a bit. Do we have in the church at this moment law that recognizes equal protection to certain persons like the canon says? First, let's note that the reference to the law here It's not referring to civil law. This is referring to canon law. And it can be tempting to look at that reference to the law here and to want to incorporate whatever standards of civil legislation that reference vulnerable adults that might be in place in your state. Now, these civil law standards can be useful in implementing your diocesan policy, and you may want to make sure that they're referenced in your diocesan code of conduct, because we certainly want to be mindful of what civil law says here and make sure that we are respecting the civil law standards. But for the purposes of this canon, which is setting forth the standards for prosecuting sexual abuse in the church as a delict in the canonical system, those civil law standards don't apply. That doesn't mean that we can't or don't do anything when those civil law standards are violated. It just means that it doesn't fall under this canon in particular. So right now, in canon law, at the global, universal level, there's only one place where you could argue that such equal protection is given, and that is the vulnerable person standard that's described in Vos Estis Lux Mundi, which we mentioned earlier. Vos Estis is a 2019 document issued by Pope Francis that enacted mandatory reporting obligations in the church, which included mandatory reporting of sexual abuse of vulnerable persons. And this is what Vos Estis says is a vulnerable person. Any person in a state of infirmity, physical or mental deficiency, or deprivation of personal liberty, which, in fact, even occasionally limits their ability to understand or to want or otherwise resist the offense. So when Vos Estis came out in 2019, it introduced this term and definition into canon law for the first time. Now, what can we say about this definition of a vulnerable person? This definition is focused on some personal condition that the person has or some state that causes an infirmity, deficiency, or loss of freedom that diminishes their ability to consent to or resist the act. It must be objective and demonstrable. Now, this is different than a person who's not otherwise laboring under such a condition, but who could be considered vulnerable in a certain situation, like where there's an imbalance of power. Now, remember that Vos Estis is about reporting. So when sexual abuse of a vulnerable person under that definition happens in the church, Vos Estis says it has to be reported and dealt with accordingly. So is this canon now saying that when a report is made, the bishop is to carry out a canonical process under Canon 1398 because of this reference to abuse of one to whom the law recognizes equal protection? Possibly. It's not entirely clear. The canon could have included that vulnerable person standard from Vos Estis, but it didn't. I think this is a sign that the church wants to leave some room for flexibility here. So if a bishop wants to pursue a canonical process for sexual abuse of a vulnerable person under the standard that's given in Vos Estis based on this canon, I think he can and should do that. But this is an area where we can expect some clarification in the future. We might also see other new laws enacted at the national, regional, or diocesan level that specify who are those considered protected under this canon. So for now, just be aware that the provision exists for others to be given protection under the law against abuse. It is new. It's not clear who it applies to at this point, but it is a step toward including protections for a broader concept of vulnerable adults than what we have had in the past. Okay, moving on to subparagraph 2. This says a cleric is to be punished if he grooms or induces a minor or a person who habitually has an imperfect use of reason or one to whom the law recognizes equal protection to expose himself or herself pornographically or to take part in pornographic exhibitions, whether real or simulated. Now, this paragraph here made a bit of a splash when it was first published because the English translation uses the word grooms, and this was interpreted by a few people to mean that grooming is now considered sexual abuse under this law. If you look at the text of the law, that's not really what it says. The crime is grooming, or maybe better said, recruiting or attempted recruitment of a minor to participate in pornographic acts. So please just take note that just because you see the word grooms here in the English translation of the text of the new canons It's not implying grooming in the sense that we're used to, where an abuser gradually wears down boundaries in order to facilitate later acts of sexual abuse. That sort of grooming is, of course, a harmful behavior and something that we need to protect against, but it's not listed as a crime here in this new canon. So this subparagraph is about involving minors, those with imperfect use of reason, and other protected persons in the creation of pornography. Under the previous law, this was understood to be included under the general category of sexual abuse of a minor. Now we have it specifically dealt with in the law, and it has been expanded now to include those protected adults. Now, finally, to the third subparagraph. This also has to do with child pornography, but the possession and distribution of it, not the creation of it. This is also not new to canon law, but it is now being added to the code. Use of child pornography has been recognized as a delict under canon law for the past decade or so. We do see that those with an imperfect use of reason are now included here as well. And the law now also says immoral possession, which allows for possession for legitimate reasons, such as during an investigation, or if it's acquired accidentally or without realizing it. Previously, the law said that possession was criminal if it was for the purpose of sexual gratification. So just stating immoral acquisition or possession here, it's a broader category. It encompasses more possible situations. All right, so we've covered all of the revised canons dealing with clergy sexual abuse. We've covered sexual assault committed by force, threats, or abuse of authority, sexual abuse of minors, those with habitually imperfect use of reason, those to whom the law offers equal protection, whatever that means, and the creation and possession of child pornography. Now, here is where the new law gets really interesting. That canon 1398 that we're looking at, that's all under paragraph 1. This canon has a second paragraph that introduces a major change to canon law. It says, a member of an institute of consecrated life or of a society of apostolic life, or any one of the faithful who enjoys a dignity or performs an office or function in the church, who commits an offense mentioned in paragraph 1 or in canon 1395 paragraph 3, is to be punished according to the provision of What that means is that all of those delicts that we just covered that apply to priests and deacons under this new law also apply to members of religious orders and members of the laity who represent the church in some way. In my opinion, this right here is the most significant change in the entire revision to the penal canons. Previously, the church only prosecuted through a canonical penal process sexual abuse committed by clerics, which would be bishops, priests, or deacons. Now, beginning December 8th, religious order members and certain laity are held accountable under canon law in the same way. This is a big change. Under the previous law, only clergy could be brought to account before a church tribunal for the offense of sexual abuse of minors. So now sexual abuse committed by a religious brother or sister or lay person in the church had to be dealt with in other ways, usually administratively. But now these persons can be formally charged, prosecuted, and punished for acts of sexual abuse in the church. So now what can we say about this? First of all, while these new delicts are being created in the Code of Canon Law, this does not affect what's covered under the Charter. The Charter is specific to sexual abuse of minors by priests and deacons. And unless there's some substantial revision to the Charter, that is how it will stay. Will the bishops decide to enact some norms to standardize their response to allegations of sexual abuse by those serving the church but who are not ordained? That's anybody's guess. They don't have to. We have what we need right here with this new canon to proceed with prosecuting these cases under canon law at the level of the diocese. So we'll see. You can see there also a summary of what this second paragraph of Canon 1398 does, which offenses are, as of December 8th, delicts under canon law that apply to religious order members and certain laity. So let's talk a bit about that reference to laity in this paragraph. We see the words in the second and third lines there, any one of the faithful who enjoys a dignity or performs an office or function in the church. What does it mean to enjoy a dignity or perform an office or a function? It's a bit ambiguous. Basically, it means that the person has been formally recognized or entrusted by someone else in church authority to represent or carry out some work for the church, whether this is an employment setting or not. What's the practical effect of this? Where previously a lay person found to have committed sexual abuse would not undergo any canonical process, they would simply be fired or let go as a volunteer and then referred to civil authorities. Now the bishop has an obligation, in the same way that he does when a cleric is accused of sexual abuse, to conduct an investigation and then a canonical process to determine whether the allegation is substantiated or not, and then to impose a penalty if one is warranted. This change will have some of the most significant effects on the local level of the diocese. Say, for example, you have a lay employee of a Catholic school who's accused of sexual abuse. Previously, that would be dealt with pretty much exclusively in the civil forum, through a criminal investigation or a process of a termination of employment, or both. Now it's not sufficient simply to call the police and terminate the employment. Some canonical process needs to be carried out to resolve the canonical delict that has occurred. Practically, this will be for the bishop and his canon lawyer to figure out what to do. Those of you who are victim assistance coordinators or do other safe environment work, however, need to be aware that sexual abuse by these individuals is now considered a canonical crime. What's not especially clear at the moment is who precisely are the laity falling under this canon. The law says any one of the faithful who enjoys the dignity or performs an office or function in the church. There's some positions in the church that are clearly established as canonical offices, such as the chancellor. Other people carry out important functions in an employment capacity, such as the school principal or director of religious education. There are others who also exercise an important function, such as lector or cantor or catechist, but as a volunteer. Do all of these people come under this new law? At the moment, it's not totally clear. My recommendation is to include all laity serving the church in any capacity under this canon when you're making decisions at the level of the diocese. It's better to be over-inclusive and possibly carry out an unnecessary canonical process than to fail to carry out a canonical process that is actually required. And as we mentioned previously, in recent years, other legislation has been enacted that holds the bishop accountable for fulfilling his obligation to investigate and follow up on allegations of sexual abuse that come to his attention, namely Vos Estis Lux Mundi. It is important to note that this change does not affect what's in the charter and the essential norms. Those documents and their related processes only apply to clergy. So at least at this point, there's no change to your local work as it pertains to your audits and compliance with the charter as a result of this canon. Now there's one last canon that I'd like to discuss that doesn't directly relate to sexual abuse, but it pertains to the obligation to report sexual abuse. With Vos Estis Lux Mundi, the 2019 legislation enacted by Pope Francis, we've mentioned it a few times here. With Vos Estis, we saw for the first time in the church instituted a mandatory reporting requirement within the church for certain harmful acts by clergy and members of religious orders. That law was implemented in 2019. Now, in 2021, we have a new canon that addresses mandatory reporting, and it makes the failure to comply with canonical mandatory reporting obligations a criminal offense in canon law. So this is the new canon 1371, paragraph 6. A person who neglects to report an offense when required to do so by a canonical law is to be punished, Making the failure to report a delict unto itself is new, and it shows the church's ongoing commitment to the mandatory reporting requirements and structures that were implemented by Vos Estis. So what this means for you and your diocese is that it's imperative that those who are mandatory reporters under canon law, not just under civil law, but under canon law too, are duly notified of this and giving appropriate training on what must be reported and how to make the report. So let's review briefly who is a mandatory reporter in the church under Vos Estis. Vos Estis states this requirement applies to clerics, which would include all bishops, priests, and deacons, and also members of institutes of consecrated life or societies of apostolic life, which are the canonical terms for what we commonly refer to as religious orders. So this would generally mean religious brothers and sisters. These are who are mandatory reporters under Vos Estis. There are two basic categories. 1, reports of clerics or members of religious orders concerning specific delicts against the 6th commandment of the Decalogue. And 2, reports of specific office holders in the church who engage in actions or omissions intended to interfere with or avoid civil investigations or canonical investigations of the delicts that must be reported under vos estis. That's a lot of words, I know. We can summarize all of this as what must be reported is sexual abuse or pornography involving a minor or vulnerable person and a cleric or religious brother or sister, or the failure of church authority to respond appropriately to such reports. So that completes our review of the specific canons that you should be aware of as it pertains to safe environment work. Now I want to conclude here with a note about a sort of theme that you see when you review the new Book 6 as a whole, which we weren't able to do today. But we looked at earlier how a full revision of the penal canons was necessary in order to weave throughout the law a greater emphasis on accountability when harm is done. This means accountability of the one who caused harm as well as the one responsible for handling the situation. And one way that we see the theme of accountability emerging is through a clear emphasis on the duty to repair harm and restore justice that we see in this revised law. In Pope Francis's Apostolic Constitution introducing the new laws, Posciti Gregem Dei, which we quoted from earlier, we have this statement. Charity thus demands that the Church's pastors resort to the penal system whenever it is required, keeping in mind the 3 aims that make it necessary in the ecclesial community: the restoration of the demands of justice, the correction of the guilty party, and the repair of scandals. Again, the words of our Holy Father, setting us off in this introductory text with a citation of what are often referred to as the 3 ends of penal law in the Church: restoration of justice, reform of the offender, and repair of harm or scandal. Now, these 3 ends are long-standing principles of penal law in the Church. But in the previous set of canons that was enacted in the 1983 Code, these 3 ends were mentioned only once at the beginning of the section on penal law as a sort of philosophical reminder that working for these ends is an aspirational goal. What's new in the revised canons is that throughout the new Book 6, there are repeated references to the obligation of restoring justice and repairing harm. This is an important signal of a change in mentality in the Church and a change in the expectations of canon law. These 3 ends are no longer aspirational goals. They are obligations. This means that bishops and those who assist him, such as diocesan staff and review boards, we all have a duty to help ensure that these 3 ends are being addressed in every case, especially the restoration of justice and the repair of harm. Now, as I mentioned, identifying these 3 ends of penal law is not new, but what's new is how they are now built into the text of the law in multiple places, which indicates that this is a real, tangible priority for the legislator. Something else that has changed is that out of these 3 ends, there's been a shift of emphasis on the restoration of justice and the repair of harm. Now, why is this important? Prior to the reform of penal law, insofar as these 3 ends were emphasized, it was mostly on the reform of the offender. And this resulted at times in less care and attention on the harmful effects of the offender's actions on the community. And we saw this in decisions that were made in the past to return a priest to ministry after he had committed sexual abuse of a minor, if the bishop was convinced that he had been reformed. If a bishop was convinced that the offender was sorry and would not commit the offense again, he was actually discouraged or in some cases not allowed to punish the offense further. So part of the reason for that was due to how the law itself was written. So these changes we see are sending a clear message as to how the law is to be interpreted going forward. We've learned a lot in recent decades to help us better understand and appreciate the harm that's caused by offenses like sexual abuse, and that even if the offender has been reformed, there's still the need to address the restoration of justice and the repair of harm to the community when a delict occurs. And as that letter from Pope Francis indicates, one way to help correct the injustices and harms to the community is by actually carrying out the prescribed punishments for crimes, even if the offender expresses contrition and seems reformed. And in cases of sexual abuse, this means permanent removal from ministry, if not more severe punishments, such as dismissal from the clerical state or a reduction or loss in financial support. There should be no more ambiguity on this point in the future. And in some ways, this repeated emphasis on the restoration of justice and the repair of harm is just the text of the law catching up to where the church has already arrived. But what's good about this is that it means that we have seen a shift in the culture and the leadership of the church that's significant enough to be codified into law. And we can ask ourselves, have we made this shift on the local level in our own diocese? Have we embraced the priority on the restoration of justice and the repair of harm? There's no place in the church that has not suffered some harm from what has occurred in the past. And there's no place in the church that will be immune from harm occurring in the future. How equipped are we to manage that? Is this something we are mindful of and working intentionally toward every day? Do we have meaningful discussions on what it actually means to restore justice and repair harm? And this goes beyond handling sexual abuse cases. It's a duty whenever harm occurs in any form within our church community. And this is an ongoing process for all of us. So this is where I believe that those of us working to promote and maintain safe environments in the church have a lot to offer. So I will wrap up with this encouragement to you to spend some time thinking about what we can do to advance this cause of restoring justice and repairing harm in the church. Our Holy Father, the supreme legislator, is telling us that this is our responsibility. And it's not something that belongs to the past. It's a duty to be taken up anew each and every day. Thank you so much for your attention and for all you do for God's people.
It seems like allegations of sexual abuse of a minor by a layperson are now covered under the law. Does that mean that any allegation of sexual abuse by a layperson must be sent to the CDF? And then as a follow-up, does that also mean that any allegation involving a layperson which is not investigated by a diocese makes that bishop subject to the possible vos estis investigations?
That sexual abuse of a minor by some lay persons, namely those lay persons holding an office, dignity, or function in the church, as of December 8th, a week from today, that is now considered a delict that's covered under canon law. However, the delicts that are reserved to the CDF have not changed. If you look at that, the canon doesn't talk about which delicts are reserved to the CDF and which aren't. That is covered in a separate document, and that document has not been altered. So what is reserved to the CDF is delicts of the sexual abuse by clergy of minors and those who habitually have the imperfect use of reason. Those go to the CDF. It's not these delicts that involve lay persons committing them. So those go to CDF. What do you do with the cases that happen locally? The bishop handles them locally because the CDF doesn't have jurisdiction over those cases by lay people. Now, as to the question of whether the bishop could be subject to a claim under vos estis if he fails to investigate an allegation that involves a lay person, it's important whenever you have questions like this, go back to what the law says and read it carefully. When we read Article 1 of vos estis, it refers to talking about the bishop, conduct consisting of actions or omissions intended to interfere with or avoid civil investigations or canonical investigations against a cleric or a religious regarding the delicts of sexual abuse. So vos estis is about reporting and investigating reports of sexual abuse by clerics and non-ordained religious. So lay people who aren't part of an institute of consecrated life or a society of apostolic life, they're not covered under vos estis. So that means, technically speaking, if you're referring to an allegation of sexual abuse committed by a lay person who's not a religious, vos estis does not apply. And therefore, a claim could not be brought against a bishop under vos estis for not investigating or following up on that allegation. However, canon law does say elsewhere that whenever a bishop receives notification of a delict, he has noticed that the delict occurs, he is obligated to investigate it and otherwise follow up on it, and not to do so would be a failure of his obligations under canon law. So a complaint could be brought forward against a bishop based on that canon. It's just wouldn't be under vos estis. There's another motu proprio that is relevant here. It's called, it's from Pope Francis, 2016. It's called As a Loving Mother. And that motu proprio laid out the conditions under which a bishop could be removed from office, or the circumstances under which you'd need to bring a look as to whether the bishop is appropriately fulfilling his office. And that document stresses that among the particular reasons that a bishop could be removed from his office, if he has, through negligence or through omission, facilitated acts that have caused grave harm to others. And it stresses in particular that this applies to his handling or mishandling of sexual abuse inflicted on minors and vulnerable adults. So a bishop could face some consequences for not following up on an allegation of sexual abuse brought against a layperson which now falls under this canon because it's now a delict, but it wouldn't be part of vos estis. It could be reported through the apostolic nunciature under a more generic claim that the bishop has caused grave harm by failing to fulfill his responsibility under the law, if that is what occurred, if grave harm occurred from that not following up. And again, this would only be for cases involving laypersons that fall under the new canon, not any layperson who happens to be in the diocese, but a layperson who exercises an office, dignity, or function, who's accused of abuse of one of the persons indicated in the canon.
It seems as though it is up to the local bishop to handle all instances of abuse involving vulnerable persons. How would this affect safe environment in the diocese today, and how might it affect safe environment in the diocese if new revisions to the charter include vulnerable persons?
First, recall that now we essentially have 3 categories of protected persons under canon law when it comes to sexual abuse. Mm-hmm. We have minors, we have those who are considered to be equivalent to minors because they habitually have the imperfect use of reason. And then we have what the law refers to, those persons to whom the law recognizes equal protection. That long, complicated phrase that we talked about in the video, which we can understand, at least at this point, to include those who are defined as vulnerable persons under vos estis. Vos estis gives us a definition of a vulnerable person. So those first 2, minors and those considered equivalent to minors, those haven't changed. Those are the same as we've been used to now for a couple decades. They're covered under the charter and the essential norms, and those cases are referred to the CDF. Nothing has changed at all for that. When it comes to sexual abuse of vulnerable persons, that's defined in vos estis. That's true. Those cases are to be handled at the local level by the bishop, like we just discussed, like any other canonical crime. They're not subject to the charter. They don't go to the CDF. We want to keep that definition of a vulnerable person under vos estis in front of us and keep referring back to it. It's one of the things you learn very clearly in canon law school is the danger of trying to go off of memory, because you say maybe what you think it should say, you don't say what it actually says. So the specific words are very important. So the definition we have from vos estis is any person in a state of infirmity, physical or mental deficiency, or deprivation of personal liberty, which, in fact, even occasionally limits their ability to understand or to want or otherwise resist the offense. That's the vulnerable person standard, needs to be handled at the local level. So your diocese needs to be prepared to address these cases if, when they occur. But at least at this point, it doesn't fall under what's covered by the charter. So what can or should you do on the local level to be prepared? If you're not already doing this, I would recommend that you offer education about this specific definition of a vulnerable person throughout your diocese. Mm-hmm. Encourage and require reporting these cases of abuse by clerics, religious, and lay people to the diocese, as well as to law enforcement, if that's if it would constitute a civil offense. Those estes already requires reporting of abuse by clerics and religious. So you could, at the local level, just expand that requirement to include abuse by any layperson who falls under your safe environment standards, church personnel, someone who works for the church or volunteers. My own archdiocese does this. We do that through the code of conduct. Any violations of the code of conduct need to be reported, and then they're processed accordingly depending on what they are. So what has changed with the new canons is that after December 8th, the bishop is also required to follow up with a canonical process. It doesn't replace all the other things that you need to do. It's just an extra thing. So it's not like, okay, now we don't do any of this, we've got the canonical process. No. It goes, it's on top of what you're already doing. You should have these protocols in place for reporting and following up on abuse or sexual misconduct by all persons who work or volunteer for the church. And so just continue to follow those. As to what might happen if the charter were to be revised to include vulnerable persons, I hesitate to even speculate on that because, one, we don't know, we wouldn't know what that means until we saw the revisions, until it happened. But as I mentioned in the webinar, with these laws, the new laws from Pope Francis, your bishop already can and must act on these cases involving vulnerable persons. Whether they get included in the charter at some point or not, or whether the bishops decide to issue maybe a document to go alongside the charter that's specific to vulnerable persons, it doesn't change. Your bishop has the canons right now to act on.
At the General Assembly this past November, the bishops did approve to expedite the review of the current charter. Currently, it's scheduled to be reviewed in 2025, but given all the changes that have occurred in the last 3 years, they thought it wise to take a look at it now and begin that process. Does canon law go retroactive to include cases prior to December 2021?
Right, so changes to canon law, they're never retroactive, right? They apply from December 8th going forward. So that means, for example, if on December 9th you get a call about sexual abuse by a principal of a Catholic school that is said to have occurred 10 years ago. You're currently living under the new law, but the actions are from 10 years ago. You have to apply the standard of law that was in place 10 years ago, which means that it wouldn't technically be a delict under canon law. What does that mean? All that means is that you still handle it like you would normally handle it today. It just means you don't have that extra canonical process requirement at the end. So it's you report it to law enforcement, you handle it just like you have been, you take care of the community. If you have any question as to how you would handle a historical allegation, make sure you take that back to your team at the diocese and get that worked out. But it's the canonical trial requirement is for new cases of abuse that happen after December 8th.
We are in the process of revising our diocesan policies. We are considering maintaining a child protection policy and a separate sexual misconduct policy to address issues not addressed in the Charter for the Protection of Children and Young People. Given the current code to these two titles or headings, makes sense, or do you recommend an alternative? Does it make more sense to have a clergy policy and a laity policy?
You need a policy to address all of that. You need it for, in our diocese, we call it church personnel, anyone other than clergy. And we have our sexual misconduct policy, because it covers everything in one document, it's really long. And so we've talked about maybe breaking it into separate documents. So I don't know if I have a specific recommendation. You need to do what's going to work best for your team locally and for your people. And the most important thing about a policy is that it's understood, it's used, and it's accessible. So whatever you need to do to make it as uncomplicated and accessible as possible.
What do you think the distinctions between office, dignity, and function mean?
Oh, I'm laughing just because that's a really hard question to answer, and I have this same question. Here's what I think. It's that phrase, office, dignity, or function, is kind of a classical one in canon law. You see it a lot in old canon law to kind of indicate a certain type of person. Office in canon law has a very specific definition. There's actually a canon that defines what it is. It's a person, holding a stable function in the name of the church, exercised for a spiritual purpose. So it's a position. It's a stable position. Like chancellor would be an example of one of those. A dignity, kind of an easy one might be Pope Francis gives pontifical honors out to lay people. So if you are holding one of these honors, that's a dignity bestowed by the church. Some sort of recognition by someone in church authority that the church has recognized you as being in a place of dignity or honor or of some sort of importance. Function is probably the loosest term there that you could maybe cast very wide. I would think it needs to be something that's been entrusted to a person, not something that, as a lay person, as a lay Catholic with my baptismal dignity, I can take up all sorts of apostolic works in my own name, on my own initiative. But it's different if like the bishop entrusts me with this, to do this, even if it's not a stable office, I'm carrying out a function entrusted to me by someone in church authority. That's how I think of it. Mm-hmm. This question has come up a lot in canon law circles. What does this mean? And we kind of keep hearing, we'll see. we'll see with jurisprudence what that means. My advice is cast it very broad. There's not much to lose by doing that.
The word lay person in the canon includes religious women and religious sisters.
Yes. Yes.
I know some will define them as laity, others say no, they're clergy, and we go back and forth.
Yeah, and there's a canon that says the state of consecrated life is neither clerical nor lay, but they are not ordained. So as a result, they would fall under that.
Okay.
It might be helpful if it had just said non-ordained persons, but.
How do we acquire a copy of Book 6 Changes?
Well, the only way I do it right now is go to the Vatican website. So it's there, vatican.va. You can get it in several languages. A lot of us are used to kind of like the red book that's put out by the Canon Law Society of America. I know they are working on a translation. So the Vatican put out an English translation, but the Canon Law Society also, at least historically, has done its own translation. So they're working on that translation, and then that has to get approved, and then they can publish the new code intact. But right now, Vatican.va is the only place I know of to go get that official text.
Where in Vos Estis is the expanded definition of vulnerable person?
Oh, that's an easy one. So that is, I got Vos Estis right here in front of me. It's if you go to Vos Estis, it's online. Again, it's on vatican.va. So you just Google motu proprio Vos Estis Lux Mundi. Should come right up for you. You scroll down to Article 1, paragraph 2, and it says, for the purposes of these norms, and then it has definition of minor, vulnerable person,
Okay.
and child pornography. So Article 1, paragraph 2B.
Does the definition of vulnerable person now include persons who may be under the influence of alcohol or drugs or other mind-altering substances? That they're now lacking the use of reason. Does it apply?
Well, and that's let's go back to the definition, right? So it says any person in a state of infirmity, physical or mental deficiency, or deprivation of personal liberty, which in fact even occasionally limits their ability to understand or want or otherwise resist the offense. So I guess the question would be is, does the use of the alcohol or drugs or the intoxicating state make a person fall into this category of being in a state of infirmity, physical or mental deficiency, or deprivation of personal liberty, which limits their ability to understand or want or resist the offense? I think you could make an argument that it does. It doesn't, I just looking back at any deprivation of personal liberty, it'd have to be demonstrable. It'd have to be kind of objective, you'd have to be able to demonstrate it. But I certainly wouldn't say that it does not. I think it's going to depend on the circumstances, how intoxicated was this person, can we show that it really did impede them in the way under the canon. That's just part of any case. You're going to have to line up what the law says with the facts and see if you get there. So.
Okay. Grooming, as commonly referred to or interpreted in the U.S., is perhaps different than the way it's intended in the new book.
Yes, yes. So, and we go back and look at what the law says. The English translation, again, is the English translation from the Vatican, talks about that in Canon 1398, subparagraph 2. It says, a cleric who grooms or induces a minor or a person who habitually has an imperfect use of reason or one to whom the law recognizes equal protection to expose himself or herself pornographically or to take part in pornographic exhibitions, whether real or simulated. So that whole definition goes together. And what some of the initial responses to this canon just kind of stopped at the word grooms, a person who grooms a minor. And then therefore it's now a delict under canon law. The law says grooming, recruiting a minor to take part in pornographic acts. That's what it is. Mm-hmm. So when I cautioned about interpreting that the use of the word grooming there, I meant that there's a lot of things that can be interpreted or can actually be grooming, whether they actually result in sexual abuse or not. And this canon is not incriminating all types of grooming. It's specific to acts that are intended to recruit or lure a minor to produce pornography or to expose themselves pornographically. So we just need to be careful that if we comes across our desk an allegation that someone is grooming a minor, that doesn't mean that this canon kicks into gear and now we have a delict on our hands. When we're talking about the use of the word grooming in the new canons as a delict under canon law in 1398, subparagraph 2, that specific canon is just talking about recruitment for involvement in pornography. That's what the new canon says. There's no other canon that uses that word. The jurisprudence indicates that when you're prosecuting a case of sexual abuse under canon law, the acts leading up to the abuse they're relevant, they're juridically relevant. And sometimes where this comes into play is if maybe the grooming behavior started while the person was 17 and then the sexual contact didn't happen until after the person was 18. You know, that's an example of where that grooming could be brought into a canonical trial. And maybe that trial could be brought based on sexual abuse of a minor based on the grooming behavior. That's kind of a technicality in canon law.
Do all of these additional allegations and such need to be included in the audit that we do for the charter?
Well, that they don't fall under the charter, right? So only thing that falls under the charter would be sexual abuse of minors or those who habitually have the imperfect use of reason committed by clergy, or priests and deacons. So no, it doesn't fall under the audit or the charter. It would take some change to the charter to do that. And Pope Francis's letter introducing this book 6 is a really important document. I recommend that everybody read it. It's not that long, but the language is very, very strong. It talks about the failures to uphold the standards of the law in the past. It says that is not to happen anymore. It's very clear that those in authority in the church have an obligation to follow up on their responsibilities. Through it mentions it in that letter. It also mentions it scattered throughout the text of the book 6, the obligation to repair harm when it occurs, to restore justice, reform the offender. I appreciated your reference to the restoration of justice in your opening prayer. And these are the words that we need to be using and thinking about. We see this in the new book 6, that insistence on that. And like I said, that's the work of the whole community. All of us to do that. What harm has occurred? It's not just about future harm or harm in the past. It's what harm is sitting here in our community.